Hi, this is Josh Blackman, and it's my honor to welcome you to the 2022 Harlan Institute Ashford Virtual Supreme Court competition. Today, we are featuring teams from Pennsylvania and Oregon. We have Emmy Maida from Baldwin School in Pennsylvania and Luisa Valentine, Emily Zhao from Lake Oswego High School in Oregon. And we'll be mooting the case of Students for Fair Admission versus University of North Carolina. Petitioners are up first. Whenever you're ready, you may begin.
Thank you.
Whenever
Mr. Chief Justice, thank you. Mr. Chief Justice, and may it please the court, my name is Emmy Maeda, and I will be representing the petitioner in today's case. Would the court like a brief summary of the facts?
Yes, please.
In 2014, Students for Fair Admissions sued the University of North Carolina over their race-conscious admissions policies. The Students for Fair Admissions claimed that by considering race as a factor in their admissions policies, it was violating the 14th Amendment's Equal Protection Clause. However, the UNC, citing Greta v. Bollinger, claimed that their policies were constitutional for promoting diversity on college campuses. This brings us to the Supreme Court with the question, is race-conscious affirmative action consistent with the 14th Amendment's Equal Protection Clause? No, race-conscious affirmative action is not consistent with the 14th Amendment's Equal Protection Clause. Despite a shameful chapter of racial discrimination in the United States, Brown v. Board of Education, and other triumphs, America has resisted racial classification and promoted racial neutrality. The idea that the way to stop discrimination is to stop discriminating on the basis of race, as Chief Justice Roberts said in Parents Involved in Community Schools versus Seattle School District. This agrees with the court's ruling in Brown v. Board of Education that ended racial segregation in schools. However, Greta v. Bollinger unconstitutionally decided that race-conscious admissions were permissible. Furthermore, the University of North Carolina's college admissions contradict Brown and reject racial neutrality. The court should overturn Greta and rule in favor of Students for Fair Admissions for 3 reasons. First, the language of the 14th Amendment is race neutral and opposes special privileges given to certain citizens, as the amendment intended to grant Black people the same rights as other citizens were guaranteed. Second, affirmative action prolongs the unconstitutional use.
Okay, counsel, if I could just jump in for a minute. So when we're talking about this case, the big roles for history, can you discuss some of the legislation that was enacted in the 1860s by Congress that might affect the outcome of this case?
Of course. So as the petitioner, we understand that some of the framers were supportive of certain affirmative action policies that benefited minorities. However, we still say 150 years later, it is a very different situation, such that the tumultuous period of transition of slavery to citizenship is now over. And in terms of this college admissions process, the interest of diversity, though important, is very obscure in this case, as it does not quantify how much.
Well, let me just pause you there. So I get that, the period after Reconstruction was very, very hectic and very chaotic. But are you really saying that whatever window for race-conscious measures ended when? 1880s, 1890s? When did that window end?
That window ended when not only were people given, the American citizens were given all the same privileges, but also the fact that all of these affirmative action policies that happened after this period were very, very temporary, and we should adhere with that temporary idea.
Justice Hicks, did you want to jump in?
Oh.
Okay, so let me ask this question point blank, right? Let's say we rule in favor of you, right? And let's say we give you everything well. We overrule Grutter, we overrule Bakke, and we say that we have race neutral admissions, right? And let's say the universities try as hard as they can to admit diverse classes, and they come back in a couple of years and say, look, our classes are basically all white and Asian, right? We have very few African-American students, very few Hispanic students. Does that change your answer? Does it matter if the universities cannot achieve the level of diversity they think they need with other measures?
The most important, the fact of the matter of this case is that the race-conscious admissions policies are unconstitutional, as the language of the 14th Amendment.
No, I get that, but what does it matter if they're unable to have any minority students, that they come back in this class to basically all white and Asian? Will that affect your answer at all? Yes or no?
That will not affect it because constitutionality is the most important in this round.
Okay, thank you. You may proceed.
Oh, proceed, thank you. Grutter also set a 25-year expiration date, yet no significant decrease in the use of affirmative action has occurred in the 21 years since, proving that proving that affirmative action is ineffective in ending racial discrimination. Now, the final point is that this case should be considered under strict scrutiny. UNC fails to demonstrate an interest that is compelling enough. Diversity is an obscure interest that is not.
Counsel, you mentioned the 25-year mark that was discussed in our opinion in Grutter, but we then reviewed another race-conscious admission process in, I believe it was Fisher. Did we discuss that same time frame in Fisher?
Well, the point of Grutter and, excuse me, well, in that case, we would say that the time frame still should be upheld, and this expiration date still stands true. So in 25 years, if affirmative action should theoretically reduce racial discrimination, however, has not.
Is your argument that race-conscious policies were always unconstitutional, even back in the 1800s? Or what's your argument there?
So while we do understand, so the race-conscious action policies were by law in the 14th Amendment, but the language of the 14th Amendment is inherently race neutral, therefore, yes. However, we do concede that the time periods were very different and it was a very different situation.
Okay,
So
thank you.
So would you say that there was a different compelling interest in past legislation than there is in affirmative action?
In past legislation, yes. However, the compelling interest in UNC versus Students for Fair Admission does not fails to meet the compelling requirement.
Well, let's talk about compelling interest, right? Counselor, do you think the university actually has a compelling interest to have a diverse class? Do you think that is actually accurate?
We do, yes, it is an interest. However, it is not compelling as it does not excuse the erosion of equality of Asian American students. And furthermore, when the UNC is promoting diversity of certain racial minorities, but ignoring the racial representation of other minorities.
So you think that part of Grutter and Bakke is wrong, defining that the educational benefits from diversity is compelling? You think that was just wrong?
In that case, though, yes, diversity does have an educational merit. However, the UNC has failed to consider race-neutral alternatives that could still promote diversity. These include considering factors such as wealth or wealth zip codes. These would still provide diversity and provide educational merit.
But the universities have told us that socioeconomic will not be enough. They run all these models and numbers. It will not get us where we need to go. And what's your response to that?
In that case, we would still say that we would, again, return to the Constitution.
The answer is basically too bad, right? If they can't, it's not enough, that's too bad.
But in that case, we would still say that, like, with the respondents' main interest being diversity, if diversity is still being accomplished with other factors, then that should be enough. And UNC has failed to review those race neutral alternatives.
Well, let me ask you, talk about stare decisis for a bit. You're asking us to overrule Grutter, you're asking us to overrule Bakke. These are half a century old opinions, right? How does stare decisis support overruling these decisions?
In this case, stare decisis does not apply in the case of Grutter versus Bollinger in this case, because as we've seen from other precedents, such as the recent Dobbs versus Jackson's Women's Health, the court has the obligation to overturn any unconstitutional or incorrect precedents. And we see this in this case with the violation of the Equal Protection Clause.
Okay, now so you may wrap up. You have about 20 seconds left.
Thank you. The case should be considered under strict scrutiny. UNC fails to demonstrate a compelling interest. It is also not narrowly tailored, as it does not consider the racial alternatives and overrides the erosion and does not consider the erosion of equality for Asian American students. I pray for the court's relief in this case. Thank you.
Excellent. Thank you so much, Counselor. All right, respondents, please come back on. I'm sorry, I forgot to tell you, please turn your camera off when you're not on the screen. I forgot to mention, so I went ahead and I turned your camera off for you, which I don't like doing, but I did here. Okay. All right, so respond.
Sorry, it says we're unable to.
Yeah, I
start.
know. I have to ask you to start it. I'm sorry. That's my Zoom fail. There you are.
Thank you. Thank
Okay,
you.
and whenever you're ready, you may begin.
May it please the court, my name is Emily Zone.
My name is Louisa Valentine, and together we are representing the respondent, the University of North Carolina, in the case of Students for Fair Admission v. University of North Carolina. Justices, would you like us to provide you with a brief explanation
Please.
of the facts?
Please.
In November of 2014, the petitioner, Students for Fair Admission, sued the University of North Carolina on the basis of their race-conscious admissions process, violating the Equal Protection Clause of the United States Constitution's 14th Amendment. Students for Fair Admission is a nonprofit membership group whose mission is to remove racial considerations from the college admissions decisions. Their claim is that race-conscious affirmative action, which is practiced by numerous college admissions offices, including the University of North Carolina's, discriminates against Asian Americans and Caucasians on the basis of their race. The defendant, the University of North Carolina, claims that their admissions process is holistic and abides by the precedent set forth by Grutter v. Bollinger. Their defense is that racial diversity on college campuses is a compelling state interest, and their admissions process is narrowly tailored as required under the strict scrutiny standard.
The question presented is race affirmative action consistent with the 14th Amendment of the Constitution?
Because race-conscious affirmative action has a narrowly tailored, compelling state interest, its honoring of stare decisis in the constitutional history allows race-conscious legislation. Race-conscious affirmative action is consistent with the 14th Amendment of the Constitution.
Today, my co-counsel will be discussing the original telos of the 14th Amendment and its permittance and encouragement of legislation that was race conscious. Followingly, I will be discussing how race-conscious affirmative action is consistent with the ruling of Brown v. Board of Education of Topeka by diversifying college campuses, and how race-conscious affirmative action follows or meets the standards of strict scrutiny set by the 14th Amendment.
All right, let's start with, I'm sorry to interrupt, Counselor. Let's start with Brown. Brown
Yes.
seems to say that racial classifications are unconstitutional, right? How does Brown support your case?
Well, Brown v. Board's decision is correct because segregation of schools has no compelling state interest, nor is it narrowly tailored. But to conclude that from that no discrimination can ever be done on an admission process is simply a false dilemma logical fallacy. Race-conscious affirmative action is wildly different from segregation because,
Why?
well, you see, race-conscious affirmative action aims to bring races together, whereas segregation aims to separate races.
Well, then let's look what UNC is doing. I mean, let's just be candid here. When you have a fixed number of seats in a classroom, let's say you have 1,000 seats in a freshman class, if you're admitting some students based on their race, you're necessarily excluding other students based on their race. You can't avoid that. So I think a lot of Asian Americans would say that UNC's policy is not keeping people together, it brings people apart. How would you respond to that?
Well, I would say that the University of North Carolina has actually said multiple times that their admissions process is holistic and that race is only a factor of a factor of a factor when it comes to the admissions process. And so race will in no way, shape, or form actually impact whether a student is rejected, especially considering the fact—
I don't know. I think I was with you to that last sentence, right? Race is a factor upon a factor upon a factor, but for some people, race will be a very important factor. So I don't think you can say it has no impact.
I wouldn't say it has no impact, but I would say that in 99% of cases, that's an arrest of estimate.
Right,
But
which
I would say
99%, is that in the record? Or you just?
No, it is not. I would say sorry, let me correct myself. I would say in most cases that race is not a make or break factor, especially when we're talking about Asian Americans. There's actually no evidence that proves that Asian Americans have been discriminated against under affirmative action. In fact, a lot of studies have shown that Asian American women are the second most benefited group when affirmative action is placed on college campuses. Moreover, I would say that race-conscious affirmative action increases the diversity on college campuses, which improves the overall educational experience for every single student on that college campus, regardless.
Let's go back to the argument from before. I'll take all your points as you're saying them. There have been some cases in American history where a person was denied entry based on his race, right? Bakke might be an example, right? Maybe Barbara Gruder and Jennifer Gratz, right? Why do you draw a distinction between racial classifications that help certain people versus racial classifications that help other people, right? In other words, how do you know when a racial classification is good versus when it's bad?
Well, what you're talking about is sort of the originalist argument that protects race-conscious affirmative action, which has to do with reparations. However, as America has evolved, the need for race-conscious admissions has evolved as well. And it's not so much as a reparation aspect anymore, but it is much more about diversity. And so it doesn't matter who we're excluding. In the end, we just want a racially diverse.
What about diversity based on religion? Why is that not important for the university?
I would say that religion is a much more difficult classification than a racial classification. Additionally,
Why? Race is simple?
Well, we understand that religion and race both fall under suspect classification. However, most people that are part of a religion spend most of their life having access to that religion, whereas people of a racial minority might grow up feeling isolated in a.
So how do I know what you're getting at, but how do you prove that? I mean, you can have a person who's a member of a very obscure faith and doesn't know many people of the same faith. I'm not sure that works.
I would also say that the framers of the 14th Amendment did want to ensure that all people who are of historically marginalized groups are being treated equally and given.
Okay, so do you have some proof for that? All people of all marginally historical, is that, where do you find evidence of that?
I would say that the idea of the 14th Amendment is that every single US citizen is treated equally and given equal opportunity to succeed.
Right. I would say that the 14th Amendment has language that is very, it's really telling of how inclusive it wants to be. It says all persons born.
I have a question. You stating that to go off of Professor Blackman's question, or I'm sorry, Justice Blackman's question about religion. I mean, haven't particular religions been marginalized as well as particular races? And so wouldn't that fall under the compelling interest to diversify the school?
Yes, I also think I would say that having religious diversity can definitely be a proponent or a component of, the beneficial impact on a college campus. That said, I believe that the current policy that is under that we are discussing refers to race-conscious affirmative action, and I'm not completely certain as to what University of North Carolina's affirmative action policy is regarding religion. However,
correct. So
go ahead, Justice Hicks. I'm sorry.
So my question is that you're stating that there's a compelling interest that is being met by narrowly tailored means, but is it being met by narrowly tailored means if it doesn't, if it's not including every particular sect of people that would incorporate diversity into an educational building?
Well, under Grutter, the main aspect they have to reach for it to be narrowly tailored is that race is only one of the aspects of a holistic application. So again, it could include religion. This actually reminds me of one of the questions that we were asked in the preliminary rounds about sexual orientation or transgender. And honestly, when we were faced with that question, it's very hard to tell, since the 14th Amendment was, the framers of the 14th Amendment intended it to be something that was related to race. So when it comes to anything else, religion, gender, sexuality, we're sort of stumbling through the darkness right now. And that's really something that's uncharted territory.
But I think something that's important to hold on to when we're looking at this idea is the fact that we cannot take the same socio or political context of the time of the 14th Amendment. Obviously, the America that we live in now is a lot more diverse in terms of the amount, like the types of people that live in America, how people identify. And I think that when it comes to the original telos of the 14th Amendment and guaranteeing everybody equal opportunity and equal treatment under the law, that race-conscious affirmative action, as well as a holistic admissions process in general, like the University of North Carolina employs, is critical in order to ensure that we actually achieve the vision set
Can we
forth.
talk about Justice Harlan's dissent in Plessy versus Ferguson, please?
Yes, Justice Harlan's dissent in Plessy v. Ferguson states, basically the idea is that like educational institutions can be separate and equal at the same time. And it basically, oh wait, sorry, no. My apologies. It basically states that this idea of like separate but equal is impossible to achieve, because by classifying different people into different like racial categories, that you are inherently pitting them against each other, essentially.
How did he describe the Constitution? He had a very famous phrase how he described the Constitution. That the Constitution was blank.
Oh, not race blind.
Colorblind, that's the word. That's right. Colorblind. What does that mean to have a colorblind constitution?
The idea of a colorblind constitution is this sort of argument that the petitioners are making, right? Which is the idea that the US Constitution promotes equal treatment. However, my co-counsel and I would argue that the 14th Amendment actually guarantees equal opportunity rather than simply equal treatment. And when we're looking at this idea of
Harlan was wrong? So you're saying Harlan was wrong?
no, I would say that the Constitution is in fact not colorblind. And that
So you're saying Harlan was wrong?
no, I'm saying that Harlan is correct and that the Constitution is not colorblind. Sorry,
No, Harlan said the Constitution is colorblind.
Well, then we are disagreeing. Charlotte.
I think Harlan's wrong. Okay, got it. Okay, you may proceed.
The framers, with the text.
Yeah, the framers of the Constitution actually, or sorry, the framers of the 14th Amendment, when passing the 14th Amendment, actually rejected numerous drafts of the 14th Amendment mandating race neutrality. For example, they stated that they rejected the proposed legislation that all national and state laws shall be equally applicable to every citizen and no discrimination shall be made on account of race and color, thus showing, in addition to, for example, the Freedmen's Bureau, as well as John F. Kennedy's passage of the executive order 10-9
Yes.
something, but that passage, it shows that their intention with the 14th Amendment was to ameliorate the negative lasting impacts of slavery, which, as everybody understood at the time of the 14th Amendment, was all African Americans.
Right.
And because a lot of these impacts still exist in the modern day United States, it is still imperative that we utilize race conscious legislation and policies like that of university.
Counsel, how do you know how does North Carolina know when they've achieved enough racial diversity? At what point have you met your compelling interest for achieving diversity? Is there a cap?
Yes, there is. There is such a thing as the critical mass of a certain race, which is just enough so that a person doesn't feel isolated race-wise.
Is that a percentage? You got to have a certain percentage on campus to make sure someone's not isolated?
No.
According to University of California v. Bakke, as well as the ruling in Gratz v. Bollinger, racial quotas are not allowed in college admissions, and we believe that this is a fair ruling because it is this idea of a diverse college campus cannot be proven through simply race, but rather through the holistic admissions process that is employed by the University of North Carolina.
Why, and this question may seem obvious to some, but why is racial diversity important for North Carolina?
Well, the University of North Carolina has stated in its actual mission that diversity is one of its core tenets. Additionally, when we're looking at the history of North Carolina as a slave-owning state, it is uniquely in a position where it needs to place African Americans on a more equal pedestal due to the negative lasting impacts of
More
slavery.
equal.
As the
More
nation,
equal. I'm so sorry. That's Orwellian. How can it be more equal? If it's equal, it's not more, it's equal.
Closer to equal, or giving equal opportunity to like African Americans and people of other
right,
races.
as the nation,
You mean more equal, you said you mean equal.
Yes.
Okay, because more equal is not equal. That's something better.
Right.
Okay, thank you for the clarification. I have about 20 seconds left.
well, we would like to pray for the, we would like to pray that the court finds that because race-conscious affirmative action has a narrowly tailored, compelling state interest, its honoring of stare decisis and constitutional history of allowing race-conscious legislation, race-conscious affirmative action is consistent with the 14th Amendment of the Constitution. Thank you.
Thank you so much. Petitioners, you have 5 minutes rebuttal time. Whenever you're ready, you may begin.
Thank you. The respondents tried to argue that affirmative action is a means to counter the effects of racial discrimination. However, when the policies itself are discrimination, and there have been, and UNC has admitted that race has been the defining factor for around 700 students. Not only is this a huge number, but even just one student who has been discriminated against based on race, that means they were violated of their constitutional rights. If even just one person's rights have been violated, these policies are unconstitutional and therefore should be shut down. So when my opponents are bringing up these obscure quantifications about diversity, there is no quantification. So when there is no strict definition, the court should not meddle in such affairs because it puts the court at risk of valuing one race's suffering over another.
Okay, so let me ask you the same question though. I mean, do you think Brown v. Board of Education prohibited affirmative action?
Yes, in this case,
But how did no one realize that for 50 years? Because Brown is like the most celebrated Supreme Court opinion of all time. Everyone knows it. Everyone studies in school. And yet you have Bakke, you have Grutter, you have Gretz, all these smart judges saying, oh yeah, we need to have affirmative action. Do they all just misread Brown and you happen to be correct?
Well, in this case, we would say the court still has the obligation to overturn these precedents. And when the Brown versus Board of Education specifically said that the doctrine of separate but equal has no place, that shows that when any sort of racial classifications, the separate has no place in any sort of policies that admit students or any policies that relate to schools or education.
Okay, may proceed, Counselor.
Thank you. Furthermore, when it puts the court at risk of valuing one race as suffering over the other, and the court has, the policy has failed to narrowly tailor itself, as it has proven time and again that Asian American students were discriminated. My opponents were incorrect in the case that when Asian American students have been constantly denied of admissions because of their race, and their race has been a determining factor. When this has happened, it clearly shows that it is unconstitutional.
Is this evidence in dispute? I mean, I know that the other side says that I think your friend said that race is never a dispositive factor. Do you have a contrary evidence to refute that?
Well, it's almost impossible for any sort of evidence to be completely undisputed when, however, the fact of the matter is that race is when race is a factor, it's enough to, when race is a factor, that's enough to violate the Equal Protection Clause, and the Equal Protection Clause in no way states that certain minorities should be given privileges or consideration over another. For those reasons, it's still unconstitutional in that case. Furthermore, my opponents say that the enrollment of people of color, underrepresented people of color has decreased. However, they do not explicitly prove why that harm needs to be avoided. Race-conscious policies are discriminatory regardless of the makeup of the class, as many precedents prove is that a university's mere interest in diversity cannot sustain race-based admissions, especially when they have not considered race neutral alternatives as well. So
Okay.
in these cases.
So let me ask you a question just to wrap up. Let's say we overrule Grutter and universities again find that they can't use socioeconomic status. Your friends on the other side said North Carolina's history of slavery and all these awful things. Is that just the answer? Is the answer just too bad?
In that case, it's not too bad because it still upholds the Constitution, which is exactly what the court should be doing. And furthermore, exactly what the court should be doing. And as we've seen from the lack of effectiveness from affirmative action, diversity cannot be achieved with affirmative action and is ineffective. So today, the petitioner asked the court to overturn Grutter and rule in favor of Students for Fair Admission to end racial segregation.
Okay, excellent. Thank you so much. If the other team can please come back on camera. That was fun. I hope you appreciate that we are asking you questions for which there are no good answers. And the reason why we ask you such difficult questions is to force you to sort of think on your feet and come to some resolution. And we're trying to pin you down. And you said this, did you just say that? And it's almost like a shock value as well, to see if we can kind of throw you off your game. And let me tell you, both teams, you stuck to your grounds. You stuck to your grounds and you didn't deviate, which is very important. I'm actually very impressed. This was actually I think one of the tough rounds I've had all day. I've been sitting here since 9 o'clock this morning, because I think both teams really did. And Emmy, by the way, you were by yourself. Her partner wasn't able to make it through a little bit of a situation, but I'm very grateful you did this solo. And Emily and Luisa, this was a very strong round. So I have some specific feedback, but I'll go first to Abby and Mick if they have any thoughts as well.
Yeah, I'll just say that you both did a really great job. I was very impressed. I mean, the fact that Justice Blackmun asked you, would it matter if there was an all white class? And you said no, because what matters is the Constitution. No, it was great. I mean, there's no right answer to it. I thought it was amazing. I was like, okay. No, great. Everybody did such a wonderful job, and congratulations.
Yeah, I'll just piggyback on what Abby said. Having that type of response to yes, and unfortunately that would be too bad. It's really important that you do that because you want a rule and you want to tell the court what you want, and you want the court to know the parameters of that argument. And sometimes it has unintended consequences, but you need to understand like what you're asking the court to do and understand how far that goes so that they're clear about that. I thought both teams were incredible. I mean, I'm so impressed with y'all's knowledge of history, and you each have your own individual style. And that's kind of one of my favorite things to look at when I'm looking at moot court advocates is stylistic stuff. That stuff really gets across to me. For the respondents in the red, what was your name?
Louisa.
Louisa, I saw you at times getting a little bit more passionate. You use your hands. I use my hands a lot, so I have to be careful. I'm constantly being dialed in, but each one of you have your own individual style and buy into that style. And don't let anybody tell you that there's one particular way to do advocacy. Advocates, they have their own style, and that stuff comes across and it's passionate. And when your passion comes out, it really helps the court, and especially in the moot court world, maybe not in the real appellate world, but in the moot court world, a lot of that stylistic stuff, the passion you bring to it, your delivery and the way you do stuff, that's going to get you a win and a round. And both teams, y'all have their own individual style, and you stuck to that style, and it came across as passionate. And I felt like I was really, involved in a real case. And so thank you. I really enjoyed that. I really don't have any negative feedback whatsoever. I'm trying to think of, I told the last team that something that I particularly struggle with is when you focus so hard on memorizing your argument, you sometimes can lose track of the questions as they're coming. And it's important that, for the big questions that are coming, have something clean and nice. Like for the question on the respondent side of why is diversity important, that's a question you got in the bag, and you got to be able to deliver that smooth and clean, and you guys did. But then there's a lot of questions that are not going to flow nicely from your script. And so you have to directly answer the question, but then know how to get off on the exit ramp. And I thought all of y'all did very well, but that's kind of me preaching of something I struggle with, is that you want to memorize your argument, but at the same time, don't be afraid to go away from the script when you're answering questions. In fact, you kind of need to at times to directly answer the questions and then pivot back. But just thank you so much for letting me join. You guys were so good, and I don't know what your intentions are, but if you do go to law school, you all three should 100% do advocacy, because you have incredible skills, inherent skills that you have right now. That will do very well for you in any public speaking role.
Very much.
Thank you.
Yeah, I'll give some particular feedback. Luis, I noticed the hand talking. I'm from New York. I am very much guilty of that, and Zoom is actually an advantage. Just keep the hands on your lap, and I'll never know your hands exist. Right? When you're in person, you'll be having your hands on a podium, right, or a lectern when you're sort of standing. So just keep your hands on your lap, and you'll never even know the hands exist. All right. So what I liked about both teams, I mean this sincerely, is you stuck to your guns. Right? You had your position. Now, so for Emma, I'm sorry, I keep saying Emma is another student. Emmy, for Emmy, I kept pushing you on, are you really okay with a campus with 0 Black kids on the campus? And you stuck to the position. You kept saying, follow the Constitution, right? I asked you, are you okay with overall, saying that Brown versus Board of Education is inconsistent with half a century of precedent? Yes. All those judges didn't know what the heck they were talking about. And I think you have to stick to that line, because if you watch the Supreme Court arguments, Justice Kagan grilled a lawyer saying, would you be okay if there were no minority students? He's like, that's not my problem. Not my problem. It's for the Constitution, right? And then for the respondents, I was pushing you very hard on the issue of the difference between good race and bad race, as I say. In other words, racial classifications to help certain minorities, and racial classifications to hurt certain minorities. And I think at first you didn't, I don't think you got the question right away. Eventually you got there to say that, I think you said bringing together versus keeping apart. And then I sort of pivoted with, the Asian American line. I thought Bethany or Emily, your answer was very strong on that front. I think you really responded forcefully to that. There are disputes of fact, but that almost doesn't even matter, because I think your answer was very confident. And then we got to the Justice Harlan part. Justice Harlan's dissent in Plessy is one of the most famous Supreme Court opinions of all time, where he said we have a colorblind Constitution. And you said straight up, we don't agree. And you can do that, right? You may not want to do it, but you can do that, right? Because this is a very celebrated opinion. And there's always a tension between the idea of a colorblind Constitution versus a Constitution that creates equal opportunity. At one point you said it was more equal. And I'm sorry, I had to jump on that. Did you read Animal Farm in remember 4 legs good, 2 legs bad, and Brave New World? No, 1984, everyone's equal, but some people more equal. No, was it all the animals are equal, but some animals are more equal?
Some are more equal. Yes, I said it and immediately cringed at myself.
Yeah, I was like, wait, what? Because I think I said that was Orwellian, and I almost felt bad when I said that, but that was verbatim a quote from Orwell. So don't say that some are more equal than others, because that sounds like Animal Farm or 1984 or something. But still, you stuck to your guns. Both of your pacing was good. Your tone was good. It was respectful but forceful. I didn't feel that you were arguing with me. You didn't fight the hypo, Luisa. I didn't hear that at all. You accepted a hypothetical. No, you asked what fight the hypothetical. Didn't you ask me that? I know that was an hour ago, a long time ago. But I didn't think you were fighting my questions. I thought you handed off one to the other. And again, Emmy, you were by yourself, which again it puts you at disadvantage, but I thought you did very well. So I have only positive words to say about both teams. Thank you so much.
Thank you so much.
Thank you.
You have questions that you want to ask me or Mick or Abby?
Yes.
I think Louisa does.
I have the question.
Of course.
So are you like mentioning my hands as a bad thing that I shouldn't do if I move on?
I would try. And this is advice you'll get in law school, in advocacy. It can be a little distracting to be completely candid.
Okay.
What a lot of people do is they'll hold a pen, which is even worse because they start flipping the pen around. It gets really distracting.
And clicking.
No,
Oh, the clicking's the worst. That makes noise also.
I did that on purpose, actually, because usually for me, when people talk with their hands, like it feels more open to me.
Oh, that's
And
interesting.
Yeah.
If you walk into any court, and I'll turn to Mick in a second, but in most courts, you'll see people with their hands on the podium just like this. I don't know, Mick, what do you think?
It really varies. I mean, it's sometimes you'll have moot rounds where you have a judge who says, I hate the use of hands. And then sometimes you'll have a judge who says, you know what, I like it. I personally like it. I think that you do have to be careful. There are certainly limitations regardless of if people do like how you use hands, but there are times to really use it effectively. I like to use it when I'm describing the two ends of the spectrum, and the most important thing when you're arguing these cases is helping the court understand at what point do you cross the line. And so I like to use my hands and say, at the starting block, this statute protects at the bare minimum this, and then it reaches all the way here before it crosses the line. Those are times where I'll use my hands if I'm trying to describe some sort of a continuum or a timeline. But it really does vary. But there are always, regardless of a judge's preference on it, there are limitations to how much you can use your hands.
Right.
I think on Zoom, maybe it makes it a little bit more difficult.
Yeah, let me say it differently, Luisa. If you don't use your hands, there is less of a risk. If you do use your hands, there's a risk a judge won't like it. So the safer approach is to not use your hands. Because if you do it and you get a judge like me, I find it distracting. But maybe Mick doesn't. So if you don't use your hands, you'll be just fine. I think your voice carries through your emotion, right? Your voice carries through your passion, and you don't need your hands to sort of as a prop.
All right. It's like a red tie.
Like a red tie, yeah. I always wear a red tie to court. That's the official South Texas moot court uniform, red tie, right, Mick?
Yeah, it definitely is. Definitely is. But I could see how sometimes people you can't wear it too long now. Like Trump's made it to the point where if you have too long of a red tie, that's a bad call. But yeah,
Abby, what do you think about the hands? I don't know. Maybe I'll ask the third person here.
I think the hands I think that your use of hands, I didn't notice it, but I think it's because we're on Zoom. But Mick has done a way more moot court rounds than I have. But from what I've gathered is that using hands effectively is a good thing. So like he said, like when you're gonna do a spectrum, I remember being in mock trial, and one of my opening statements was a plan, a policy, a push. And so it made it visual, but I think just flailing your hands around is very theatrical, and especially for moot court, it can be really distracting for the judge because you want to hold on to the podium and make them listen, make them lean in, make them hear your argument and not be distracted by the hands.
Okay, thank you.
Talk to the hand. Oh, that we don't do that anymore. What other questions do you have? Anything about law school? Anything on your minds?
I had a question. So there were a few times in the argument where I felt a little cornered, or like I said something that I regretted saying. And I was wondering how I should handle that sort of situation.
I'll let maybe Mick and Abby handle this one, but it's actually a really thoughtful question. What do you guys think?
We're all human beings and we make mistakes. And sometimes admitting that, you maybe you misspoke or, kind of chuckle about, oh, I apologize if I misspoke or misled the court. It's totally okay to backtrack and it lets the court know you're human, and it kind of breaks down some walls and the fiction of the idea that we're up here, just giving this perfect argument, because no one does that. So I think that if you did misspeak, you can say I misspoke, but it is kind of funny. That is another place where it does kind of vary between judges. I like to I've apologized before. I've said, oh, I'm sorry if I misled the court, but let me be a little bit more specific. I've heard some people who tell me don't ever apologize, but I do. I know some advocates who do here. What's most important is that you can clearly articulate what you're arguing for, not necessarily that every word you said was perfect. So I think it's totally okay to backtrack. And sometimes when you don't have a direct answer to something, it's also okay to say, Your Honor, I don't know the answer to that, but I can tell you what I do know. And what I do know is this. And so, it's totally okay to misspeak or not know the answer to something, and to be candid with the court, because ultimately what's most important is not that you're perfect, is that we all can try to have a good discussion about it and get the rule right, for the good of the community, right?
Yeah,
Yeah, that's
I would say that when you feel backed into a corner, or you've misspoken, I agree with Mick. I apologize too. I've heard from judges not to apologize. It's part of who I am. I don't think I'll ever stop saying my apologies. It's naturally part of who I am. And also what I've heard a lot, is it's okay to pause. When you're being asked a question, it's actually really good to pause and think about your answer. And even though it might feel awkward in that moment, it really gives you an opportunity to think about what you're going to say. And it also makes judges feel like their question was very good. So you take a second and you pause, and then you can answer the question. And also remember that most of the time the judges are really trying to understand your argument. So just to be helpful, I actually think Mick told me that one day, just to be helpful in answering their questions. So when they're asking a question, even though it feels like sometimes they're asking to get you backed into a corner, a lot of times they're just not understanding something. So always just have a demeanor of being helpful, and don't be afraid to pause before you respond.
Great, thank you.
I have a question.
Lisa?
What do you think is going to happen in Students for Fair Admissions, the University of North Carolina?
Well, I'll let Mick and Abby also share their thoughts. I think the universities are going to lose. I just don't know how. This is a court that doesn't have much patience for the racial preferences, and they don't draw the line you do between preferences that bring people together versus take people apart. I think they'll say that these are actually taking people apart. I think they will accept the argument that Asian students are harmed. I know there's dispute of these facts, but they're going to accept that. What I don't know is whether the court rules on the grounds of Title VI, which is a federal statute that you mentioned, the Civil Rights Act, or they rule on the basis of the 14th Amendment, or both. Keep in mind that Justice Jackson is recused from the Harvard case, so she can't rule on the Title VI thing, not that it probably matters very much, but they may choose to rule on the constitutional issue in North Carolina. What I do know is that, what year are you, sophomores, juniors, seniors?
We're both
We're
seniors.
Are you seniors and you're on mute, I'm sorry.
I'm sophomore.
Sophomore, okay. So for those of you who are seniors, whatever, you're applying to colleges now, you might be the last ever college class admitted under an affirmative action policy. Sure. I mean, you might be one of the last ones. Now universities are going to try and fight this kicking and screaming and resist it every single way they can. Like they're not going to like it. But a lot of the things that are certainly said in text messages and emails will come up in litigation and will not look pretty for the universities. There's some, you probably read the record, there's some very ugly text messages at UNC. People should said things in text about, we got to admit this brown girl. I know, oh yeah, he's just Asian, they say these things in emails that really should not be written. So I think the university is going to have to do things quietly to try and evade the ruling, but it's going to be very hard for a big school like UNC.
Right.
Oh,
Yeah, I tend to agree. I think they'll issue an opinion that will, give all of these incredibly great reasons why racial diversity is an incredibly compelling interest and it's wonderful. But the way you get there, it's so vague. Like if you go back and listen to the oral arguments from all of these previous affirmative action cases, a lot of, especially the conservative justices are asking like, at what point do we achieve critical mass? And if you can't give a physical number because it violates, what another case said about having a quota, then how do you know what critical mass, the term just implies a number, and so it's a very hard rule and line to draw. And maybe there's some cases where there's not a clear line. But courts are always looking for a clear line. And with these affirmative action cases, the rule is just so vague and it's just so hard to figure out when you've achieved the diversity necessary.
All right, what other questions?
May I ask a question? So, about law school, like it's still like way in the future for me, definitely. But are these the kind of things that happen, these moot court competitions, things that happen there?
I model this tournament as if you were all law students.
I see.
If you wonder why I'm being so difficult to you, even though you're 15 or 16 years old, I'm treating as if you're a first year law student.
In
I don't
30
hold-
minutes.
I don't hold anything back. Ask Mick, and this is how I treat my students in my own class. This is it. So that's how much I think of you. It's not a sign of disrespect, it's a sign of respect. I think you can handle it.
And he gave you a super hard case to do it on. It probably could have been a little bit more clear cut case, but this is a really difficult case and you guys crushed it. And many of pretty much every moot court round, y'all are better than a lot of the law school advocates that I've seen in competition. Like y'all would really do incredibly well in moot court in law school right now, right this second.
Yeah, this is the exact kind of stuff that happens actually in 30 minutes. I'm about to go through the same thing that you guys just went through with a group of guest judges about a Dobbs case. So this is
No big
yeah.
deal.
No big deal.
But I hope to see all of you in law school in about 6 or 7 years. I think you're going to do great.
Thank you so much.
Thank you.
All right, wonderful. Have a good day, and we'll be posting the scores probably Thursday or Friday. Okay.
All right, thank you
Thank
so
you.
much.
Have a
good
great
one.
day.
All right, the students sign off. Judges stand for a bit. Okay, turn off the recording.